After losing out at the tribunal and appeal court, Abba Yusuf's governorship hangs in the balance, with the Supreme Court being his last chance. And he got a semblance of redemption when electoral body INEC told the 5-member Apex Court panel headed by Justice John Okoro that the key witness, whose testimony was the ground for deducting the 165,616 votes of Yusuf deemed unlawful, was subpoenaed and that his evidence should not have been admitted. INEC's counsel, Abubakar Mahmood, said the witness statement should have been inadmissible, having not been front-loaded along with the main petition at the tribunal. He said the illegal votes that informed the decision of the tribunal to void Yusuf's victory were arrived at after the recounting of votes was done privately at the tribunal chambers, adding that when the contested ballots were brought to the Court of Appeal, however, they were never demonstrated. On Yusuf's membership of the NNPP, INEC's counsel stated that it is the internal affair of the political party concerned and not for an external body, citing previous decisions of the Apex Court. He stressed that the Kano issue was a pre-election and not a constitutional matter, and as such, the court lacks the powers to decide. Abba Yusuf's counsel, Wole Olanipekun, says it's rather unprecedented to use guidelines of INEC as a basis for nullifying the electoral victory of a candidate who won by a margin of over 100,000, stressing at no point in Nigeria's electoral cases was an election nullified on the grounds that ballot papers were not signed or stamped. Counsel for the APC urged the Apex Court to affirm the sack of the Kano State Governor, with the Apex Court reserving its judgment after all parties in the suit adopted their briefs of argument.
As you are well aware, there are 9 appeals filed in this appeal. Of course, the Supreme Court collapsed all the appeals into one. That is the one filed by Abba Kabir Yusuf, the candidate. And that appeal was taken. All the other appeals will abide. Arguments were canvassed, briefs were adopted, and the judgment has been reserved by the Supreme Court. The date for the expiry of this appeal is 14th January. So, of course, we expect judgment before that date.
The Supreme Court has also reserved judgment in the Bouchi governorship matter after the APC and the PDP Council adopted their briefs of argument.
Electoral materials that are required to carry certain information are omitted by INEC. Those materials, in respect of the affected polling units, will invalidate the election in those polling units, not the entire election. But the question is, how broad, how wide were the infraction that we have under Section 73(2) as to know whether it affected the outcome of the election. So that's what the Supreme Court is now going to look into, especially when the tribunal agreed that something happened that should be left to the conscience of INEC to explain.
For NNPP, New Nigerian People Party. What happened here? Well, today the matter was scheduled for the hearing of our appeal, which we filed against the decision of the Court of Appeal. And we are happy the court has heard our appeal and judgment was reserved. But the way the court has taken our appeal, we are hopeful. And the way that by the demeanor of the court, God willing, this our appeal will be allowed. And by God's grace, the judgment of the lower courts, that is the Court of Appeal, will be set aside.
Are you blamed to the court? No, could you actually say it was one major argument you hinged your appeal on this one?
Well, there was only 2 arguments that were in the appeal. The issue of membership of our candidates, that is the engineer Abba Kabir Yusuf, which was a settled principle of law. This court, Supreme Court, has settled it. The issue of membership is non-justiciable, is no-go area, is an issue that has to do with the party. No any other member that has the power, that is the locus, to come and challenge the membership of any other member of another political party. So that is an issue that was settled. And again, there was issue of the ballot papers that were detected by the tribunal, which was affirmed by the Court of Appeal. That issue too has been understood by the court, because even the court was asking, was it right, even if it is the case, was it right for an offense that has been done by an INEC to be visited on an ordinary voter? So, but that was the only case, and then that was where we are saying, hopefully, this appeal will be in favor of our candidates, and God willing, we are going to win this petition. I mean, this appeal. Thank you. Bashir Yusuf Muhammad.
We believe in the integrity and the impartiality of the Nigerian judiciary. The judgment is reserved, and I am reserving my comment until after the judgment. Thank you very much.
Election matters have finally reached the last lap, and it's finally the moment of truth.
Going forward, I'm not asking you to preempt the court or to decide who they should suggest who they should, in whose favor they should rule. But what legal precedents or legal principles are likely to be at play, in the minds of these judges? What legal precedents and principles will they consider in making their final judgment?
If you look at Section 6 of the 1999 Constitution, the court is established for a particular purpose. And the purpose for which the court is established is to ensure that justice is not only done, but manifestly done. So the Supreme Court's duty is a search for justice. It's also a search to state whether or not the courts below erred in law, or they did what they are supposed to do by law to ensure justice. Now, if you look at the case, two issues come up prominently. That, Yusuf was not a member of the political party as at the time he contested that election. That was one. And that two, that a huge chunk of the number of votes that he scored were not signed, sealed, and stamped by INEC. Those were the two issues that the APC used at the tribunal and the Court of Appeal. Okay? Now, these two issues are quite controversial. They are controversial in the sense that if you look at the issue of membership of political party, it does not lie in the mouth of another political party to determine whether a person was validly nominated in his political party or not. It's an internal wrangling of the party that you don't need someone from a cross-reference party to make that assertion. That is one of it, which boils down to the election issue that would have been contested within the same party during the primaries. That was what it should be by law. The second has to do with the number of votes scored that were not stamped. The doctrine of equity is actually that to ensure justice, you don't actually visit the sins of an institution's on litigants. Okay, if the litigants have approached the court to seek redress, and you are saying because of the action or inaction of an institution, therefore the party who the dereliction of the duty of the institution affected adversely cannot go ahead just because the institution which the litigant does not have control over. That does not amount to manifest justice. So whichever way it goes, the Supreme Court will decide, because at this level, it is the last threshold for which justice will be handed down. But I don't see, at the risk of not preempting the Supreme Court, I do not think the two courts, I do not agree with the first court, as the tribunal, and the Court of Appeal. Okay. I do not agree with that submission, because to me, it does not present a case of justice. It is quite oppressive to do that. Okay, that's my own perception about it. But the Supreme Court can take a different decision, whichever way it is. Okay. The Supreme Court can even root out an issue that, is not contemplated by both parties.
But Evans, talking about, what the tribunals and the appeal court came up with, or the Court of Appeal rather, at this final appeal court, which is Supreme Court now, do you think that what was the judgment in the presidential election appeals that went to the Supreme Court might set the tone for which way these justices may look? Because maybe we can argue that something similar, if not the same, was on the table for the presidential election petitions.
Well, yeah, there's a sense in which the Supreme Court will follow its precedent, even though it has the prerogative to overrule itself if it so wishes. But the truth is that the regular principle of law is that when a precedent has been established, like in the case of the presidential election, and the Supreme Court has settled some issues, okay, those issues, when they arise in other cases, the Supreme Court is most likely going to toe the same line. The similarities in the case abound. We have seen certain similarities, and these similarities, they are still predicated on the discretion of the Supreme Court to so decide. Because if you look at it deeply, similarities or not, no two cases are the same. No two cases are the same. Because if you look at it, the governorship election, how be it that you have similarity in this case, the case of Kano and that of what was decided by the Presidential Election Tribunal, they cannot be absolutely the same, but similarities abound. Okay. So where similarities, flow through, the Supreme Court is most likely going to toe the same lines as established already.
Regardless of the Supreme Court's decision, whichever way it goes, what are the political and social, ramifications of the judgment, which regardless of whoever wins for Kano State? Are there possibilities we might have, societal unrest, political instability, uncertainty, whichever way the pendulum swings?
There is already political unrest in Kano as we speak. Kano have a long history of political, riots and arrests from the Kano riot of 1953 to 8. There is that proclivity or tendency that because the two actors, how be it that they are sharply divided, they have supporters in very huge country. Is a political flashpoint of the country. Kano, Lagos, Port Harcourt, Abuja, and Kaduna, they have that semblance of having huge political quotient, capital. And that political quotient or capital calls for followership. And this followership, they have a tendency to go to the streets. Already, when the tribunal gave that judgment, though there was no widespread, as it were, in the Court of Appeal judgment, I think the tribunal judgment, they did it even by Zoom. Virtual judgment. The judgment was delivered virtually. Yeah. And then you get to the Court of Appeal, there was already widespread uprising. Someone was even killed at that time before that arrest was quelled. Now, at the level of the Supreme Court, to whichever way the Supreme Court goes, there's a tendency that this will not sit down well with certain persons. And the court will have to bear this in mind and determine exactly how it's going to deliver that judgment. But my proposal will be that the federal government will have to deploy more security to that part of the country before the Supreme Court deliver that judgment. Okay. To ensure that after the judgment, they're able to curtail the excesses of the followers who may want to foment trouble or use the pronouncement to create a situation where there will be a breakdown of law and order. That is very probable. Okay. So the federal government must be proactive about this, given the sensitive nature of the decision the Supreme Court is going to hand over. The Supreme Court is not going to rule that both parties won the election. It's going to rule that one person won the election and the other lost. And that may also spark some issues of violence.